Chelsea, are you ready?
I'm ready when you are.
We're almost there. You guys ready?
It would have to be some.
You ready? Ladies and gentlemen, it is, by my watch, 10 o'clock, and it's time to call this meeting to order here. We do have a quorum, so we'll, without any further delay, go ahead and get started. We're going to have an opening prayer by Pastor Taylor Day from Valley Creek Church. If you would please, Taylor.
All right. Okay, God, I just thank you for today. I thank you for this time. Lord, I just ask that you give every person here wisdom and discernment in every decision made. God, I just pray that you guide our words, guide our hearts, and guide our decisions. And we know that this time is yours, so may it glorify you today. Amen.
Amen. Thank you very much. Appreciate it. And I'll lead our pledges. Pledge with me, if you would, the American flag. I pledge allegiance to the flag of the United States of America and to the republic for which it stands. All right, we're going to, I know we have several people that are wanting to make public comments today, and we have a list on the podium up there, so rather than taking your names down beforehand, if you get up to speak and I'll recognize you, go ahead and sign your name to the list that's on the podium when you get up to speak, if you would, as well as identify yourself. And by all means, try to keep your presentation to the 3 minutes or less that you're allotted by rule, okay? Otherwise, we'll be here all day long listening to comments, and we'll try to get everybody's in, but let's give everybody a fair chance to get theirs in too. So with that in mind, we'll move on to item number 6, which is the consent agenda. And the consent agenda includes non-controversial and routine items that the court may act on with one single vote. The judge or a commissioner may pull any item from the consent agenda in order that the court discuss and act upon it individually as part of the regular agenda.
Nobody has anything. I'll make a motion. We approve the consent agenda.
Consent agenda motion, Commissioner Snuggs, to approve the consent agenda. Do I hear a second? Second, Commissioner Hollowell. All in favor? Aye.
Aye.
Any opposed? There are none. The consent agenda passes 5-0. Item number 7. We're going to open a public hearing regarding request by Pedro Torres for a replat of Lot 29, Block 2, FRF Estate, Section 2, Valley View. We'll open this public hearing at 10:04. Does anyone have anything to say about the plat in FRF Estates?
Pedro here.
Is Pedro here? What do you know about it?
It was kind of interesting. He split it up last year, and now
Yeah.
it was like just through email, wasn't it? I mean, did he come into the office?
Oh, he's been in. Yeah,
Okay. Yeah, we can close the hearing.
Okay. Item number 8 is we're going to close the public hearing at 10:05. Item number 9 is to deliberate and consider possible approval of the request by Pedro Torres for replat of Lot 29, Block 2, FRF State, Section 2, Valley View. Does anybody have a,
So they split it into 2 lots and now he's wanting to put it back into 1 lot. I'm not sure what's going on, but that's a no-brainer. So I'll make a motion, we approve this request on the replat for FRF Estates.
motion to approve the replat by Commissioner Snuggs? I'll second that motion. All in favor? Aye. Any opposed? And there are none. That motion passes 5-0. Item number 10 is to open a public hearing. The request by Michael Mitchell to replat lots 1009 and 1010 in Lake Kiowa back into 2 separate lots. Is Michael here? Once again, do you know anything about this one?
Judge, you got a time to open it?
Oh, I'm sorry. We're going to open this public hearing at 10:06.
They put them together to get where there wasn't 2 sets of dues. I guess they were gonna keep them both, but now they want to split them up to sell them, and Lake Kiowa POA signed off on it, so we're just in the public hearing, so.
Yeah, right.
And there's nobody here to, go ahead.
Okay, no one is here.
Jason, would you speak up?
Oh, yes, sir.
It's hard for us to hear.
Yeah, on this, the Lake Kiowa POA has signed off on it, so they take good care of their homeowners association, so we can close the public hearing if there's nobody here to speak to it.
All right, no one is here. Item number 11 is to close the public hearing at 10:08. Item number 12 is to deliberate and consider possible action regarding the approval of the request by Michael Mitchell to replat lots 1009 and 1010 in Lake Kiowa back into 2 separate lots.
Motion to approve.
Motion to approve by Commissioner Snuggs. Second, Commissioner Sicking. All in favor?
Aye.
Any opposed? And there are none. That motion passes 5-0. Item number 13, one more public hearing. Request by Joshua and Lisa Fowler to replat Lot 1, Valley View Farms. Is anyone here representing?
What time you open your hearing?
Say again? I'll get to that. Let's go 10:09.
Are the Fowlers here?
Everybody.
Fowler's not here,
Okay.
but the neighbors are here. Do we have the right to speak?
Yes, you do.
Those of us, the land in question to ask,
Identify yourself. Identify yourself.
Oh.
Make sure and sign too.
yes, sir. My name is Brian Hoffman. I'm actually the adjoining neighbor to this property that's in question. The property, the area of Valley View Farms has been deed restricted when we all required it or purchased those properties. They're originally 10-acre lots. In the deed restrictions, it says they can come down to 2.5-acre lots. Mr. Fowler is looking to divide those into smaller than 2.5-acre lots. He's always been an opportunist with not his neighbors necessarily in mind. So before we did a civil court deal, we would like the commissioners to look at going, hey, this is what was already here. We would like to keep them at least 2.5 acres and minimize the amount of access that's coming off of the county road if possible. But that's really where we're at. We would like to try to keep everything at least at 2.5 acres. Otherwise, there's nothing to say that we can't just start stacking trailer houses and things of that nature. The tornado did hit us last spring. I've had neighbors that had existing property or buildings that were grandfathered in. They've had to build new domains, new structures to meet the restrictions. And I would just like the Commissioners Court to uphold what was already there. The Rioses, which is down the road, when they bought their property, they wanted to split it between 2.5 acres for father and son. At that point, the Commissioners Court denied them, leaving it as one property, stating that the property had already been divided from a 10-acre into 2 5-acre lots. So I'd just like you guys to take those previous actions into considerations. Like I said, the neighbors don't have any problems with anything going below 2.5 acres, but we would like to keep it at least a 2.5-acre plot.
When did that change from 10 to 2.5? Do you remember that?
Judge Roan, I've sent the deed restrictions to Mr. Snuggs.
Okay.
I've actually got a copy of them here. But this actually dates clear back to 1983.
I would say that the deed restrictions have been in place since the land was subdivided.
And to hold that 2.5 acres? Okay.
Yeah, and it doesn't have anything to do, it's just that land, it's not P and Z, so.
Okay. And no one is here to represent the Fowlers?
They've already left for Florida and have no intentions of coming back.
What are the majority of the lot sizes out there? What size is yours?
Mine is a 2.5 acres.
Okay.
Mine is the smallest one and the only 2.5-acre lot. Everything else on that is either 5, 7 3/4, or 10+ acres.
Okay, there's multiple sizes. Mr. Love, is he here? How big is your lot, sir?
10.1.
Okay.
And it's got, so this is, looks like it's 2 lots that were large enough where he's doing 4 lots, 2 acres, 2 acres, 2.8 and 2.8-ish, something like that. It's in the drawing there. It's a little hard to see, but it's.
That's what I was trying to do.
Yeah, so he's got 2 large lots, wanting to subdivide it into 4 lots to sell them all. And it's got, they're flag lots, but they're wide enough in our subdivision regulations to be allowed, but they're at the minimum for the flag lot, so.
He's actually trying to do 5 lots there, Mr. Snuggs.
Huh?
He's trying to do 5 lots currently.
Oh, it's 5? I
It's
missed
5
it.
lots,
Sorry.
as I'd stated before. He's trying to retain the 2 acres along
Okay.
35 so that he can try to strong-arm the Bolivar water system.
Okay, that extra one on the lot, okay, on the highway.
Yes, sir.
I was just counting the big one.
No, it is actually 5 lots. There's 2 acres along 35 that he's trying to hold to.
But 2 of them don't meet the 2.5 acre rule anyway.
No, well, it's not, so it's not our, it's in their deed restrictions.
Yeah.
The 2.5 makes you associate it with our rule and the P and Z, but it's outside the P and Z. But I feel like we need to stick with
But
their
we
deed
can't
restrictions.
enforce.
We can enforce them, but, you know, I feel like people buy land with deed restrictions, we ought to assist in that.
Just a recommendation.
We're still in a public hearing.
Right,
I mean, that's my thought, but does anybody else want to speak to it?
Anyone else to speak on this item here? If not, we'll close the public hearing at 10:14.
I'll speak.
Oh, I'm sorry.
Sorry. I gotta get her.
She can come with you.
Yeah. If you would you please sign in and identify yourself, please?
Where's the new
Item 13?
the new drawing?
Yes. I'm assuming.
We're on item 13, yes.
Just checking. I guess I'm Mariah Alvarado. I'm a neighbor of the plot that's in question. I guess I'm talking for the wants of some of the neighbors, and, you know, that is, the more people, that's not what we bought into. We respected the deed restrictions, and we'd like for them to stay respected. Because we're just doing it as neighbors. We try to respect each other. If we all come together and we want something to change, that's fine. If we all come together and we don't want something to change, that's kind of where we're at. So for my children, I don't really want a lot of neighbors, but I understand things change. But as a community, as our little neighborhood, we don't want this to change. And speaking to our neighbors, we're happy for them in Florida, and they definitely, we're happy to see them go, because there was not a lot of respect that they showed people. And that's disappointing, but we have to keep going. So,
All right. Thank you.
thank you.
Yep, thank you.
Thank you so much.
Anyone else would like to speak on this item 13? If not, we will close the public hearing at 10:16. Item number 15 then is deliberate and consider possible action regarding the approval of the request by Joshua and Lisa Fowler to replat Lot 1, Valley View Farms.
On this one, I'll make a motion that we deny it as it is, and I'll ask Kathy to let them know that to redraw it, to resubmit if they would like to.
Okay, once again, is this a recommendation?
This is a motion.
A motion?
Motion for denial.
Okay.
To minimum 2.5.
Yeah, minimum 2.5.
You hear him, Kathy?
All right, Commissioner Snuggs makes the motion to keep the lots on this particular plat at 2.5 acres, therefore denying the Fowler's request. Do I hear a second?
2.5 minimum, Judge, I think.
That's right.
Hello. I'll second.
Second, Commissioner Hollowell. All in favor?
Aye.
Aye. Any opposed? There are none. Item 15 passes, or it does not pass, does not meet the approval. The request is denied. Item number 16, open the public hearing regarding the issuing of a special use permit to Frederick P. Cummings for the construction of overnight cabins on the property located at 920 County Road 231, Valley View, Texas. Such a request has been denied by Lake Ray Roberts Planning and Zoning Board, and the owner has given notice of appeal. We'll open this hearing at 10:18. Who would like to speak? And like I say, if you would, please.
Yes, sir.
Identify yourself and just put your name on, your information on the sheet.
So my name is Jacob Scoggins. I'm the architect helping Edge of the Lake with their project. So we've been through this twice before with the winery and with the wedding venue. All of the things that we spoke about then, the drainage, the light pollution, all the things that we're going to address on those hold true today. So those are unchanged with this project. I think you can see right there, I'll speak to the project a little bit of what we did. About a year and a half ago, we came through with the hotel project, and that was not received understandably. And so what we try to do is address what we think is a need in the area, which is the lodging component, but try to minimize the impact on the site. And so, as you can see, we've spread out the sleeping quarters over about 9 or 10 acres, spread it apart, put landscaping, a very nice retention pond that would address the stormwater concerns that were raised previously. And then it'll be, the design aesthetic will be much more in line with Cooke County. So single-story buildings, pitched roofs, not as modern as the hotel was being presented. As we went through the Lake Zoning Commission meeting, I think the main takeaway, and I don't want to speak for anybody else, but my takeaway was that we had a viable project potentially, but the main question was whether we fit more closely with the motel, motor court definition or a bed and breakfast definition. And so we had to pick one, and so we chose with the bed and breakfast to submit it as a specific use permit, and for a few reasons. Because I think there's arguably a route to go either way. Our position on the bed and breakfast is, for one, the owner-operator will live 50 yards from the cabin community, so that's a distinguishing factor. Whereas if you do a motel, usually the owner is not on site. But if you just do a quick Google search between a motel or a motor court and what we're presenting, it's really two different projects. And so we're not the squeezed together density, relatively low quality construction and design, and I don't mean that as an insulting way, it's just a different product than what we're presenting here. And so that's why we did. The specific use permit. The other position that we have is with the specific use permit, we're allowed to present a very narrow project. So if we were to come in as a motor court or a motel, it would be a zoning change request. That's not what we're doing here. We're trying to be very narrow in what we're requesting to be approved, which is the overall development. And so I think that benefits everybody in that if we deviate from the plan drastically, well then we're no longer in the bounds of the specific use permit. And so we're just trying to do our best with the ordinance that we know that we have, and so that's kind of where we're at. I'm happy to answer any questions related to the project design that you may have, if there's any concerns. The owner is committed to really addressing anything that we can within our power. There's some limitations, obviously, with water and those kind of things, but we're in the middle of trying to figure all that out right now with Bolivar and some other things. So, excuse me. So, happy to answer any questions.
How many actual units are we talking about here?
So on this plan right here, there's 40 cabins, single room cabins. We may have a double cabin, but they're all going to be under about 800 square feet. Most of the cabins will be 400 to 600 square feet because they'll have a bathroom. No cooking accommodations. It'll have a small warming kitchen, we call it, with a microwave, but no ranges. That way we keep the safety factor kind of where it needs to be at versus having ranges in all the development. So they're not true dwelling units by the definition of the building code.
And approximately what acreage are those 40 cabins going to be on?
Right now, it's a little over 9. Most of that, frankly, is taken up by the retention pond, though. You can see it's very large in what it is. There's a pond there now, but we're going to reshape that and, one, make an amenity out of it, but two, by our initial calculations, it's well oversized. So during the Lake Zoning Commission meeting, one of the concerns was the runoff that's put forward to the road, and there's some bigger issues there that isn't specific to Edge of the Lakes property. I think it's more of a countywide issue in that area because the road really doesn't have any ditches. But what we're trying to do here is really capture as much water as we can so that we're not impacting anybody off-site for stormwater runoff. And it'll have to be navigated with the Army Corps as well because we're adjacent to their property.
How wide is that road that goes around there? Is that a road or a walk path?
The circular road around right now I have it at 20 feet, which is the minimum for a fire apparatus. That's negotiable though. We can manage that as we, and then it kind of veers off for parking.
So you're gonna have parking on that 20 foot? Are they gonna park at each one of them?
So 20 foot parking's in addition to that. So when it widens out, maybe about 30, 32.
Who else would like to have something to say here? Pardon?
No more questions for me?
Not right now.
I have one.
Oh, go ahead.
How far apart are they?
The cabins? Generally, well, it depends on where you're at on the curve, but no less than 10 feet, which is required by the building code. But on average, I think it's about 12 to 15 feet to the nearest corner. So as they splay out on a curve, it'd be wide on the backside. Any closer, we'll have to fire rate the outside of the building, which is common building code. Which number? Is this 16? I'm sorry. 16?
Yes.
Okay, sorry.
Any other questions for this speaker?
The two on the lake, I should have mentioned that previously. So there are a couple of bit larger cottages, I'm calling them. The one in the middle is an overlook. So it's just two buildings with sort of a deck. So you can enjoy your coffee, looking at the lake. So we didn't. But again, all the structures would be single story, so with a pitched roof. Nothing more than.
Any other questions? Next speaker.
Hi, my name is Chris McIntosh. First, I wanted to relay a message. My father was planning on being here today to speak with you guys as well, but we had a death in the family this morning, so he's in the middle of arranging to get out to Georgia to handle that. I wanted to just kind of follow up with what Jacob said. I think a lot of thought went in reshaping our original scope of work, and a lot of that was due, despite what people think or say, that we were listening to the objections of the first project, of the hotel. That they didn't seem like a fit, it didn't match the aesthetic of the lakeside view, and so we really dived hard into reconfiguring what that looks like and making it function. And I think we've done a really good job of that. And there's the amount of property break between where this is and the neighbor or the road. It's at the very furthest north part of our west side of our property. And as you can see, it butts up right next to my house that I live in. I would hope that all that would alleviate some concern of lighting issues and noise. There will be a winery, a parking lot, and a whole vineyard before the road. There won't be any issues with lights. The way Jacob designed the road and had the parking, more parallel parking inside and not pull-in spaces, would help with some of that light distribution as well. But the main thing that I wanted to say today is this past weekend we had what we call, the burning of the vines at our vineyard. And before anybody goes, the county knew about it. I called everybody. We had a Valley View Fire Department truck there, made a donation to them to make that happen. Did everything we could to make sure we followed every rule. Part of that ceremony of burning of the vines is to throw out the old and begin a new path for the next year. As I was putting together my speech for that, for our customers and friends alike that came, I couldn't help reflect on this whole journey here. There is growth coming, and I know that what we're asking for is looking for a little bit of variance in description on a special or specific use permit, because there's nothing in the zoning that describes exactly what we're trying to achieve. I don't think that should prohibit progress from coming. I think everybody up here is aware that there needs to be some new workings of the planning and zoning, more descriptions, and I don't think that we should be penalized because there's not something that describes what we're doing. You're going to have housing developments. There's one that's being proposed on the same street that butts up against my property line as well. And I just think that we need to be considerate of that development. If you're going to start putting in housing developments right around the corner from us, you need some sort of business to offset some of that tax revenue to balance things out. And we've been a good steward of that land. Despite what people say, we want to minimize impact to our neighbors, but we also want to proceed forward. We have really slowed down, taken a pause on any development, opening up satellite locations for our winery in different cities, which is some part of our long-term plan because we needed to get this done. So now I'm about 2 years behind on my business plan and my father's business plan. And so we just ask that the commissioners take that into consideration. I know several times in this journey, the phrase has been said that making a decision once does not set precedent on future applications or proposals. So I don't think there should be any concern that you guys make a variance to our proposal because of the lack of description, that it would set any precedent for future projects that didn't meet the codes and restrictions that you guys have set forth. So that's all I have to say, and I appreciate your guys' time.
Chris,
Yes, sir.
in our packet is a letter from Sid Miller.
Yes.
Is he aware that that's in the P and Z?
Yes, he is. I actually had that conversation with Snug, so I went back to the original email that was sent, and in that, it states that we are in the Lake Ray Roberts Planning and Zoning, went before you wrote the letter. I know there was another conversation had with the Assistant Commissioner Hunter, right? Where he wasn't aware that it was in the P and Z, but Sid Miller and his staff was aware. Yes, sir.
Okay.
Any questions? Who else would like to speak? I know there are.
Goodbye. Not gonna wave at us or anything.
Good morning.
Good morning.
Thank you all for taking the time. Again, allowing us to offer these overnight stays in cabins as a part of the winery and the venue offerings and experiences would give guests at edge of the lake and the county the opportunity to experience nature and life in the county, to enjoy the vineyard and Lake Roberts, explore the city of Valley View and its businesses, and also the surrounding vineyards and wineries. Adding this portion to our project is vital to us as well as the city of Valley View and Cooke County and its businesses. It'll add significant tax revenue, allow us to improve infrastructure to the property and surrounding areas, and continue to add more high-paying jobs to surrounding residents. Obviously, we've been here a few times now and have listened and heard concerns from locals, which is why we've pivoted from obviously building the hotel to building these cabins, which is essentially hiding them from everybody's view driving by. I'd like to start with the letter of support from Texas AG Commissioner Sid Miller. In the letter, he states, expanding this business will enhance viticulture production and align with the Texas Wine Industry Development Act, which promotes the growth of wine-related industries, is vital to our state's economy and public welfare. Texas voters' recent approval of the Prop 1 further highlights the importance of protecting and supporting agricultural enterprises like Edge of the Lake Vineyard. Edge of the Lake would play a key role in agritourism. Agritourism defined involves a wide use of definitions. However, it involves an ag-based operation or activity that brings visitors to a farm or ranch. One of these uses, it does encompass a wide range of activities, including direct-to-consumer sales, such as hospitality services, such as overnight farm stays. These activities provide an additional source of income to help sustain overall businesses such as ours at Edge of the Lake. In Sid Miller's reference to the Texas Ag Code in section 58.002A and D, it states agricultural business is defined as a business that is or proposes to be engaged in producing, processing, marketing, or exporting an agricultural product. And any agricultural related business in rural areas of Texas, including a business that provides recreational activities, including hiking, fishing, hunting, or frankly, any activity associated with the enjoyment of nature and the outdoors on agricultural lands. The Texas Ag Code was put into place to protect agricultural industries such as the wine industry. He also references the Texas Wine Industry Development Act in Chapter 50B.001, Findings and Purpose. The legislature finds that it is in the public's interest to encourage the orderly growth and development of sustainable, labor-intensive, value-added agricultural industries such as wine grape growing and wine-making industries. The production and distribution of wine and wine-related products constitute an important industry of this state that stimulates tourism and provides substantial and necessary revenues for the state and employment of the state's residents. Pursuant to the Agricultural Code and Chapter 50B of the Texas Wine Industry Development Act, the support of Sid Miller and hundreds of locals and customers in the area, we feel the addition of the cottages to the vineyard would enhance the city of Valley View, Cooke County, and contribute significantly to the surrounding community, and we hope to get your vote of support today. Thank you all.
Thank you. Who would be next? And let me throw out the reminder again, 3 minutes for presentations, if you would.
Okay, good morning. I'm Diane Staley, and I'm here to talk to you all about the intent of Edge of the Water. They came before you all and the Planning and Zoning Board about a hotel, which was shut down immediately. Their intent now is to substitute these 40-plus cabins for the hotel. This is something that is not allowed in the Section 3 land use regulations. I have given you all a copy of that so you can review it. And I express to you that it really should be looked at. We went before the Planning and Zoning Board just recently, and there was an extensive discussion about these cabins. There was a consensus from 5 of the members that this is not something that is in the planning and zoning land use regulations. It is not allowed. There's no vehicle that allows this. Jason was there as our county commissioner. He heard the extensive talk about what their intent was, and he saw that 5 of them voted this down. Now, there's no reason, there's no basis today for an appeal. This is not a fit, it's not allowed, and it's high time that we start paying attention to the planning and zoning rules and regulations, and also be familiar with them. And Jason, I hope you today speak up loudly about the rules and the regulations and about the last planning and zoning meeting and how serious all 5 were about this situation. It's very serious. There should be no appeal today, and this should be shut down immediately.
Thank you.
Thank you.
Of course.
Thank you, ma'am.
Thank you.
Thank you.
Good morning, everybody. I'm back again. Some of this is going to be similar but different. I do not understand why we're here for an appeal on this application either. The application applied for something that doesn't exist in the planning and zoning rules. And there's nothing in the planning and zoning book that allows this to even be applied for. You have the definitions there of a bed and breakfast and of a motel. This does not fit a bed and breakfast in any way, shape, or form. It's an owner-operator residence with bedrooms available for overnight guests, not cabins. The definitions are very clear in the planning and zoning, and this very clearly fits the motel definition and very clearly does not fit the bed and breakfast definition. If you read the land use regulations that we have, you will see the only specific use permit available for motels is in the commercial and industrial section of the P&Z rules. Anytime you can drive to a building, it's rented overnight. It's transient in nature because it has different people coming at all times. You drive to it, you park, you go in, that is a motel. That is the definition of a motel. They are expressly prohibited on ag zone property. Everybody needs to remember, this is agricultural zone property we're talking about. This is not commercial. One of the reasons in support of this application is that they posted Texas Law 58002, which Hunter read, and that paragraph is out of the rules and regulations. The second paragraph on that page is the agritourism definition out of Wikipedia. It has nothing to do with the Texas laws and does not exist in the Texas laws. The second support letter, which has been talked about, is from Sid Miller, who's the Texas Ag Commissioner. We have all had Sid Miller's support of the winery brought up at every meeting to do with the edge of the lake. The newest P&Z member, Richard Womack, in doing his due diligence for the meeting, called Commissioner Miller. And during their call, he asked Commissioner Miller if he was aware the winery was in a P&Z area. The commissioner told Richard that he did not know that it was in a P&Z area when he wrote the letter. I also had questions on this. On 9/26/24, I emailed Commissioner Miller's office and sent the comprehensive planning and zoning regulations and a copy I had of the application in the email. I didn't hear back for 10 days, so I called the office and spoke to Corey, who is Mr. Miller's assistant. She looked back and found the original email and forwarded it to Dan Hunter, whom she said it was over wineries and legislation. He called me and read me the Sid Miller letter, as it was not in the application that I had received. And he said they are familiar with the Edge of the Lake winery, but we're not aware they were in a zoned area. I asked if wineries are exempt from zoning regulations, and he said due to the expanse of most vine fields, there weren't many in zoning areas, but if they were located in a zoning area, they would be bound by the zoning regulations. I asked if motels and wedding venues were considered agribusiness or agritourism. He said both are considered commercial in nature and have no connection to agriculture in any way. I asked if motels or wedding venues could be built in support of a winery or be built in connection with a winery and be considered agriculture. He reiterated they are both standalone commercial businesses with no connection to agriculture. He said he had looked at the application and that it was a commercial motel by the site plan. He emailed Jason Snuggs and Gary Yost and told them that neither motels nor wedding venues were mentioned in Sid Miller's letter because they are not connected to agritourism, which the letter was supporting. There is no legal way to overturn this decision from the P&Z. To overturn the P&Z 5-0 decision, not follow the zoning laws, would break state and local laws and be illegal. The P&Z was set up and put into law by the Texas legislature. I've included a paragraph in your copies that is referred to in Texas courts. It says the Texas Supreme Court has construed Article 5, Section 18 to mean that although a commissioner's court may exercise broad discretion in conducting county business, the legal basis for any action must be grounded ultimately in the Constitution or statutes. Thank you for your time.
Thank you. Anybody else like to speak to this issue?
I got a question.
Oh, I'm sorry, go ahead.
I want to be sure I understand this. You say that it is a criminal offense or illegal for us to override a P&Z decision based on what's written there?
No, what it's saying is the statutes and the laws must be followed. The zoning commission was set up by the Texas legislature, and the Texas legislature authorizes zoning rules. Those are state legislature rules, local and state laws.
Okay, then we have the rules, the P&Z rules, and in those rules, does it not allow for an appeal?
Yes, it allows for an appeal.
So if we couldn't overrule them, why would we have an opportunity, why would a subject have an opportunity to appeal to us?
Well, let me ask you this question back. What are they appealing?
Well, I'm not talking about in this instance right now. I'm talking about in general, because we've obviously agreed and disagreed with the P and Z over time. And, I certainly don't break the law.
No, I understand
And
that.
so, again, I'm not talking specifically about this, but what I heard was, based on legislation, we can't override these. And I point to you guys, not just, it's P and Z. And so, I don't,
What I've learned from the attorneys that I've talked to is because this is not a legal thing in the zoning regulations, if you approve something that is not legal in the zoning regulations, then it is breaking the state and local laws.
oh.
Because it's the zoning regulations, and this is not in the zoning regulations to be approved. It does not fit anything in the zoning regulations.
Okay.
There's nothing in the zoning regulations under agriculture, if you look at these, that allows for overnight accommodations. Because it doesn't fit bed and breakfast, because the owner is not living in the building and renting out a bedroom.
So you're basically just saying we have to follow the regulations.
You have to follow the laws of Texas, which are the regulations, is what I'm saying.
Well, but, I agree, but we are the ones that either wrote or had prepared for us our P and Z guidelines, and we signed off on them.
Based upon what
So-
the Texas legislature set up for the
They
zoning
gave us some
district.
guidelines, but we wrote it, and we approved it. And once that's approved, then we should be able to follow it.
Yeah, you have to follow the rules, is
Yeah.
what it says.
Okay. I just,
Yeah, no, that's just
I
basically
sensed
what
some, I
that
sensed some
paragraph is.
implication there that maybe we had or might do something
Yeah,
illegal.
I think it basically boils down to just follow what's legal in the zoning regulations.
And so, I'm gonna play the devil's advocate, y'all know I always do, for pros and cons, but, the, under ag, on the chart you provided me, it talks to bed and breakfast, okay? And not based on our definition, but the definition of Google of a bed and breakfast is, a guest house or small house offering sleeping accommodations and a morning meal. Okay, so both of those are allowed under the ag.
But in your
In our
definition
definition,
is bed and breakfast says it's an
So-
owner operated.
and I don't know
Or
that that
owner-occupied.
definition is subject to interpretation or not.
So, what part did you just say that is allowed?
Both of these, well, one,
Oh.
I happen to asterisk wedding chapels from earlier. Bed and breakfast, under the ag,
Right.
okay? Guest house, under the ag.
Yeah.
This is not a guest house because it's being paid for by night. It's rented by night for a room. If you read the motel definition, it fits the motel definition because you got to go by the definitions in your rules.
Well, and this is guest house or small hotel offering sleeping accommodations. So, and then my question on that would be if they provide breakfast, does that make it commercial?
It's commercial if it's 40 places to rent overnight in a motel and you drive to them and you park and you go in.
But it's not, I don't know that it meets hotel. The definitions may be lacking. If we follow this to the letter, we probably have.
Guest house definition is used without renting or leasing.
So, okay, thank you, man.
You're welcome, thank you.
Thank you.
I would just like to say, I do have a letter from the email that I sent to Lindsay, where it is mentioned twice about being in P and Z for this project. And a lot of people have said that wasn't reference to them and we were hiding, but that is false. And I can send this email to whoever, or I can bring my phone up and you guys can look at it real quick, wherever you guys need.
I'm curious, Gary, can you help me? What was the vote for the P and Z? 5 members, 5-0.
We have Mr. Yost here. Gary, would you like to get up and just explain some things to us and kind of tell us your thought process when you...
Sure.
Since you made the trip, well, we certainly ought to...
I was gonna ask him to speak after we got out of the hearing, but it's same.
Same thing, yep.
Good morning, I guess. My name's Gary Yost. I'm the current chairman of the Lake Ray Roberts P&Z. We met on 11th of November, had a public meeting on this application for cabins. And we got a presentation from the applicant, and we had 6 people there that spoke in opposition of the application. One of the first things we have to do as a P&Z before we get into compatibility, infrastructure requirements, blah, 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 is just to check and see if it's allowed in that current district. When we looked at the application, which was for cabins, it wasn't for a bed and breakfast, you know, as Debbie says, it more closely fits the whole motel definition than any other definition there, and that motel is strictly prohibited in an agricultural district. A bed and breakfast is allowed under an SUP, but as everybody has said, it doesn't fit that. It's you know, owner or operator occupied residence, which is singular in that case, which has spare bedrooms for guests. After we closed the public meeting, it was discussed, and it was consensus of every member there that it was not allowed under the existing regulations. And so it was recommended for denial by 5-0 vote. And I'll be happy to answer any questions.
No, anybody have any questions? Okay. Thank you very much.
You bet.
Appreciate the job you guys are doing too, by the way. I think I have another speaker back here. Oh, I lobbed it over. That's right.
My name is Kevin Norris, and I live right across from this proposal. Even by his own admission, that I'd be impacted more than anybody up and down the road. First of all, I can't imagine anybody wanting 40 rooms with a transient population being put up next to that without any rules or regulations or anything like that. I agree with this should have never made it to this point. My take on this is when you apply for a special use permit, the zoning thing says that they're supposed to meet with you, Judge Rome. And to my knowledge, they didn't. And if they met with you, you could have told them that they didn't have a vehicle for this proposal, and it would have saved us a lot of time and trouble. So it's another one of them rules things, you know.
Let me, at this point, change that just a little bit.
All right.
Regardless of anything that says the judge does this or the judge does that, it's always implied that Commissioner's Court does that. And as you probably all know, we can't meet to discuss things beforehand. So that's why it had to wait until court. And even though it's requested that I send them information or meet with them and make a decision or whatever, it's really not possible under our rules if you assume that Commissioner's Court is who actually makes decisions by a majority vote, so to speak. I may be the spokesman, but I'm not the end-all, be-all, so to speak.
Right. We had a preliminary meeting with Mr. Yost and I before they brought it to the planning and zoning, but like I told you on the phone, I mean, people can apply for what they want. If they want to go tell the commission they want to build a 5 million room hotel, I mean, I can't tell them not to apply, they can apply for what they wish and take their chances to, you know, be denied for recommendation or not. You know, it's not my place to say, hey, don't apply, you know.
And is it not everybody's opportunity to appeal?
Right, and,
Sure.
and they can appeal whatever they want to appeal to, that's their rights within the rules. So the rights within the rules, they can apply for what they want, whether it's ludicrous or very great idea, or they can, and if they don't like what they hear, they can make an appeal. That's just people's rights. It's not mine or Judge Rum's right to say that they can't do those things,
Right.
if that makes any sense.
And then, like I said, one step farther, the judge isn't the decision maker in this group here. It's a majority decision. I may be the spokesman, but I'm not the final decision. Let's put it that way.
I think what he meant is the zoning commission rules
Right.
ask the judge to do things, but we delegate the power between both of us. So-
Right.
And we have that.
Well,
right
it
to
goes
do that.
back to the letter asked that I make a ruling before we came to court, actually. And that's not possible. It has to be a commissioner's court ruling. And then I'll speak for commissioner's court.
Okay, well, I agree with Mr. Yost and Dale that this should not go forward. It should be voted down. It doesn't fit in with anything. I don't care what kind of buildings they put up there. There's 9 families that live down this road, 10 if you count their household. And every one of them is involved in agriculture in some way, except for one, and it's because of acreage. Cattle raising, horse breeding, and hay production. So they're not the only ag on the road. I mean, there's plenty of ag. It doesn't fit anything that's down the road. I ask you to vote no. Thank you.
Diane Staley. There's a lot of anger in the Lake Ray Roberts zoning area. These people have come to the P&Z meetings, Commissioners Court, have really dedicated a lot of time to make this area and keep this area a beautiful area. Speaking with them the last 2 weeks, they would like this temperature to go down. And the only way this temperature is going to go down is to start paying attention and abiding by the rules and regulations of the planning and zoning. And it specifically states in there that this is not a fit.
Does anybody else have anything to say?
I just have one clarification. When you asked me the number of units, it's 40 cabins, but I have 2 cottages, so it's 42.
So 42 in all?
Yes.
Okay.
I mean, just a case that's
All right. Anybody have any questions of any of our speakers, or?
Close your meeting, Judge.
That's what I'm about to do. All right, it is now 10:59, and we will close the public hearing, which takes us to item number 18. Deliberate and consider possible action regarding the approval of issuing a special use permit to Frederick P. Cummings for the construction of overnight cabins on the property located at 920 County Road 231, Valley View, Texas. I will,
Go ahead.
first of all, I think the request was that I'll make the decision, and, which we've already discussed, by the way, but I'm going to make the decision that we do not approve the appeal, that it not be approved, and several reasons. You know, if you go back to the very beginning here, when the when Ray Roberts was opened up for habitation, for instance, was there not a minimum size that lots were supposed to be? And can anybody remember what, it was 2.5 acres or something?
No, sir. It was
10 acres?
It was 10 acres in
I-
1995.
Okay, and did that then get changed? However, it's not like 42 units on 8 acres of land or whatever it happens to be, okay? That in itself, to me, makes it hard for me to believe that this is a bed and breakfast. A bed and breakfast to me is a single unit. I mean, we've all stayed in a bed and breakfast at some point in time. A bed and breakfast to me is a place where you go and spend 2 or 3 days and you have breakfast every morning with the other guests, and you know, it's the old-fashioned thing and everything else. This is a motel as far as I can tell. I know you may disagree with that, but to me, it's just like any motel that I've stayed in for all my life. So for a number of reasons, I'm going to make the motion that we deny the appeal.
That's your motion?
That's my motion.
I'll second that motion, but I want to talk.
Go right ahead.
So on the other things that have come before us, the wedding venue and the addition to the winery, we had some gray area on those, and I leaned on the definitions for that, and those things were allowed by special use, but the hotels, motels, I've been very clear from the start, they're for commercial zoned areas, no matter how. So, I mean, you know, to lean on our definitions like I have the whole time, I'm seconding that motion.
Okay. So we
But
have-
I know Gary's got plenty to say, so.
Okay.
What makes you think that?
I just know you.
Do any other comments?
I got to tell you, I'm normally a property rights person. I support the concept. I think it would be neat. But I have to take into consideration the 5-0 vote. I have to take into consideration that the density of those 40 cabins concerns me, because in our subdivision guidelines, when we're talking about RV parks, they're a minimum of 40 foot apart, 1 pole every 40 foot, and only 1 unit per pole. So I'm concerned about density. I don't always agree with our P&Z rules, but based on the definitions as written, I don't think that they meet the guidelines.
And with you, that's one of the things I had to mention in our P&Z vote. They voted on the rules, you know. That was a good meeting. It was not based on, they voted with their mind and not their heart, which is how that P&Z is supposed to work. So, and they all thought it was, like you said, a neat concept, but it's just not allowed in the rules. You know, Chris, I've been straightforward with you from the start that something like this was going to take a large variance or a rules change to get this step of your project. I haven't wavered from that.
And the density concerns me. Is the reason I asked the question about distance. We're talking about 10 foot apart. And, you know, our logic on the RVs, and I realize this is not an RV, was health and safety and trying to be able to get fire and EMS services in. And then the close proximity, one catches fire, they may all burn. So that's my input as far as this particular request and my observation.
Any other thoughts from the rest of the gallery?
I have the same concern about, and I asked that with the fire. I sent Chief down in Valley View a message, he hadn't heard nothing about it, so that concerns me too. To put them fire departments in a position where they're trying to save people, or say if a tornado come through there, which it could, that it's just so tight together. It's just, it's a neat concept, I agree with you, but from right there, it's not gonna work.
I'm sorry, you're asking me to respond to that, or just for the comment?
I don't know if you,
We're out of public comment.
yeah, we're out of public comment. I mean, we're just telling you kind of where I'm looking at. I mean, I'm not saying I'm voting yea or nay yet, but, that's just too tight of quarters for having people, and then our health and safety. If one of those units catches on fire and you try to get people out of there and the fire truck is trying to get in. I mean, like I said, our RVs regulations are more stringent than that. And you're trying to get tighter, I can't go with that for that reason.
And see, if we approve that, then all the RV parks are gonna come back and say,
Right.
what's up?
And I understand what you're saying with the response to that. If it was something that was approved in the rules, we could have addressed spacing and stuff, but it didn't get, not that far at this point.
I just like to share my rationale if I'm gonna.
Yeah.
Yep.
Method for madness.
Yeah, I mean, like I said, I'm huge property rights, but, and, you know, I've said all along, we need to revisit our P and Z guidelines too. Because, I mean, there's certainly room to debate bed and breakfast versus motel and all that, but our definition of bed and breakfast kind of limits the conversation.
Well, if needed, I can address that.
You might want to save that, whatever additional comments y'all might have. You might want to save that for somewhere down the road or something like that. But at this point in time, the motion has been made to disallow the appeal. It's been seconded by Commissioner Snuggs. All in favor?
Aye.
Any opposed? And there are none. Your appeal did not pass 5-0. Okay. So, thank you for your patience, and it's been a trip. Somehow I have a feeling it's not over. But at any rate, you're always welcome to court to come back and visit anytime you want to, or conduct business anytime you want to. So,
Yeah, thank y'all.
thank you very much. Appreciate it. All right, item number 19. Deliberate and consider possible action regarding the approval of accepting the available surplus items from TxDOT for FY25 up to the allocated amount of $26,966.
What do they got for us?
That's what I was wondering. I don't see anything on the list other than guardrail and used asphalt. Somewhere I saw that, but I didn't see it on this specifically, how much they had or.
What's up to an amount?
It came to me, it came to us in the mail. I think once they get something like a list of stuff, they send it in the future, but you just have to say, we want up to this amount.
Okay.
And send them a nice little letter that I put in there and signed.
I think
But in the
you're right.
future, I think they send out a list of stuff.
I guess that's just our amount based on our county. So
Yes.
I make a motion that we approve. I make a motion that we approve.
Motion, Commissioner Snuggs, that item number 19 be approved. Do I hear a second?
Second.
Second, Commissioner Sicking. All in favor?
Aye.
Aye. Any opposed? And there are none. Motion passes 5-0. Item number 20 would be to deliberate and consider possible action regarding the approval of paying the vacation, holiday, and personal time in excess of the carryover limit for the communications supervisor.
Good morning.
Well, good morning, Sheriff. How are you?
Better not deserve to be.
Well, that's debatable.
So, throughout, this past calendar year, we had 3 vacancies for a long time. We've got two hired. We have several applicants. We should be able to fill the third one pretty soon. So, but anyway, due to that, as well as we brought on a new operating system in November that we've got live across all platforms now. But anyway, because of that, Brittany has 31 and a half hours of vacation, 18 hours of holiday, and 6 hours of personal. As we stand here today, that she hadn't been able to take. She may be able to take a little bit between now and the end of this month. But we've just asked that she be paid for it. She was able to give the other 6 operators their time off so that we wouldn't be facing the same scenario with all of them. And then again, she may be able to take a little bit of this time between now and the end of December, but I know that she's not going to be able to take all of it. So.
I don't have a problem with that. I didn't even know that this had to come before us if it was in the budget.
It's not in the budget.
Okay.
No, well, it's not overtime,
Well,
so
I mean, it's extra.
it would come from unused salary.
That's what I thought.
Money
yeah.
is where I would presume it would be paid, but, I mean, that's why the time wasn't able to be taken, because we had the vacancies and so forth, so.
I'm glad to hear that you're filling some spots and things are going better.
You bet. Of course, you know, when you hire them, typically, there is a time period there. Fortunately, one of those first 2 we hired was a communication operator from Wise County. So she's pretty much on her own now.
Hit the ground running.
So the other one is coming along well. And there again, we had to drop, the priority was the new operating system that we had to get going in November, and we are rolling good. It's doing fantastic so far. So now we can get back and focus on filling that third one that we had. Like I said, we have several applications for it, and feel confident that one of them will work.
So did the pay increase that we did you feel like that helped with it? Okay. That was it was a big decision. I'm glad we went with it, so.
Let me ask you this, is there any of that time, personal time or anything like that, any of that time that could be given to somebody else? Could she voluntarily give some of her time to another employee?
I don't know about that, Judge, but I wouldn't want to ask her to give her time away when she couldn't physically take it because she's working.
Sure.
And so you basically would be saying, well, we're not going to pay you for it either. So, I mean, to give it away.
Well,
I don't feel like she deserves to have to give it away.
well, but what I was looking at, if the regulation is use it or lose it, okay, and if it came down to she was going to lose that time and it just went away, wouldn't it be better to give that time to someone that maybe
I don't
was?
know that our policy allows that.
Okay, that was what my question was.
Sheriff, this 31 hours, is this above our carryover rate?
Yes. All of this time is she's going to lose it
Okay.
after December 31st, so.
I mean,
Even the holiday, we have 19 accrual.
yeah. I mean, I know the person devoted, done a heck of a job. I understand the shorthandedness. That's not my concern. My concern is setting a precedent, particularly on personal days, because we've had employees that just didn't get their personal days.
I think
So it would help us, I mean, I think it would help if we could get her to take as many days as you could stand between now and first of the year, you know.
Totally.
First 2, I would,
Totally agree.
know,
And
'cause, I mean,
I'm not saying that these are the hours that would have to be paid, because she's going to shoot and try to get some more hours used. I just know she's not gonna be able to get them all. She knows she's not gonna get them all used. And the time, we didn't want to wait till the last second to come before you.
The only reservation I have is we can't do it for everybody. That's,
Well,
they'll have
and-
circumstance.
And, you know, and
Or we can choose to change that, but do we want to? Yeah.
so I've been in office about 4 years, and I think this is the first time I've had to come ask you to do this. So it's not something that I'm going to set as a standard. It's something that very unique circumstances this past year, and I'm very proud of Brittany, very proud of her. But as hard as she worked, and we could have easily collapsed with 3 short, and we didn't. And we stood up, she made it happen, and I think she deserves that we pay her for her efforts and not penalize her for coming in and making it work.
I'll make a motion that we approve, as long as, like Gary said, if, she'll try to use some of them between now and then. Or maybe
Well,
some of
let
the
me-
others will step up and let her get
She
full
absolutely
time
needs
off.
to use the personal.
Let me ask another question here real quick too. What gives us the right to make this decision? If it's in the handbook, if it's already determined that this is the way it is, what gives us the right to make this decision?
That's my concern. But
Yeah.
again,
Well, and-
you don't want, I've seen her, I know what she's been through, and they're being shorthanded. So
Because it's well,
it's not
Maybe
your spot. Now,
Elizabeth-
we could have another elected official show up a year down the road and say, hey, we got the same issue.
Well, I could say it right now. I've got 4 people off today just to try to get vacation done.
yeah, that's
Yeah,
what all my guys will be off from now till January. 'Cause I just have to deal with it every December.
But the
It
problem,
sucks, but-
yeah, again, he's gonna pay overtime or something to cover, while she's off.
And also, at what salary would we pay this?
Well, he's
Whatever
got-
her going rate is, whatever her salary is.
But he's got money in the budget line.
OT, overtime,
But I
time
mean,
and a half.
okay, but does that include the recent raise, or is that?
Yes.
Okay.
When I visited with Elizabeth about the issue, Elizabeth was the one that advised me that you need to go to court and get approval for her to be paid for those hours.
Because it's outside of
Thank you,
policy. Yeah, thanks, Richard. Outside of policy, yeah, that's what she's, I'm sure. I don't, anybody got any suggestions?
We have a motion to pay the overtime from Commissioner Snuggs. Do I hear a second?
I'll second it, but just, like I say, we all got, but hers is a little bit different.
If she goes home, nobody's answering 911.
Right. That's something we get caught. We get it, we can say it in EMS too. They get, I can remember having some comp time before, and you got work, you can't get nobody to come in for you, and you get down to the end, you're like, what
I
I
pay
do?
my comp time out if I have it in the budget. I get that.
Well,
off.
we pay comp time out.
Which is kind of similar, it's just
But you try to get them to where they're, use that.
100%. But that position's been in a bind, that's why I came to y'all and
But
begged we
I've probably got,
raise those salaries so they could hire some people to fill it.
out of the 10 guys, I've got probably 6 of them that are over their max on their vacation. They just, over during the summer, we just work. We got,
My guys, same way.
We just-
They're all about to be off until January,
Yeah.
except for like the rookies.
I'll second the motion.
We have a second, Commissioner Arndt. Any further discussion?
So you're explaining to me again why she's so far behind because of the new software getting in? Is that what you said a while ago?
So the 3 vacancies were a lot of it, where She just physically couldn't take off. She was allowing the other 6 operators to get their time taken, but she hadn't physically been able to take off. And then the new operating platform, which we took a lot of work prior to November, and then we went live, we had that week of training. In fact, she just couldn't physically get off. It was just, I mean, now I'm not saying that she's not going to be able to take off some of these hours between now and December 31st. I think she will be. But she's not going to be able to take it all off. So,
See, I don't think we've ever paid out personal. I've got guys lost personal, so you,
yeah, we can commit to getting 6 hours of personal taken. That's, I mean,
16, right?
It's
said
6.
Or 16? 6.
31 and a half hours vacation, 18 holiday, and 6 personal. But I'm telling you, we can get a day or 2 more whittled off. But it's just physically not going to be able to get her all off.
So explain to me how your rotation works. You got 6 other people, right? Is that what you said? 6 other operators?
Leading up to this point, we only had 7 operators, right? So we didn't have enough. It would take 8 to make 2 in the day and 2 at night, 7 days a week, 365. But we only had 7, so it's left.
During this period, you run with 4, right, Sheriff? You typically staff 7, right? And you had 3 short, so you were running on 4?
We should have 10.
10, okay.
And we were operating with 7.
That way they can take it.
Which I told you when I came before you during budget.
They're 40 hours. It's on that 40 hours. So
The only way to make it with 7 folks
12s.
is half of the day, half of a day, somebody's going to have to work by themselves. We're not going to have two folks in there. So we were picking days during the week from 12 midnight till 12 noon. There was just 1 person in there. We were doing everything we could to make it possible to operate with those vacancies. Brittany ensured that the other 6 operators who had similar time, that they could take their time. Be honest with you, that's what I expect a supervisor to do. Step up to the plate, take care of your folks, make sure they get off, and she did. So, but because of that, now she's stuck with time that she can't take off. She'll be able to take off some, but not all.
They don't have the luxury we have of being able to run 1 or 2 short and let some folks off. But again,
It's got to be answered, period.
yeah,
And when there's a single person in there and they have to go to the bathroom, guess what happens? That phone sits there and rings for a little bit. I mean, it happens. Or somebody's calling in, somebody's shooting at me. Somebody's got to be at that mic. They got to get them help.
Nobody's saying they're not important.
Right. I mean, that's.
I don't think you're setting a bad precedent. I think you're, like I said, this is the first time in 4 years that I've had to ask you for something about this, and it was because of unique circumstances. So,
It's a one-time deal, right?
you say one-time deal, right? Yeah, I mean, that's, well, yeah.
I mean, he's got the money in his budget. He's got the money. Yeah.
Well, and, yeah, okay.
It was probably. I mean, it was budgeted for whether she's going to get it or not. I mean, no. Her vacation time is budgeted. So,
Yep.
just because she didn't use it now, yeah, we're gonna have to pay. We paid some money, but it's still there.
did the second. Commissioner Art. Okay, all in favor? All opposed? Nay. Motion passes 4-1.
Thanks, sir.
Thank y'all very much.
All right,
Thank y'all.
what is next? Thank y'all.
Thanks, Gary, for being here very much.
Thank you, Gary. All right then. Executive session in compliance with Texas Open Meetings Act, or
I got one deal.
you have one deal in executive session, okay? In that case, may I ask that we clear the courtroom?
go grab a towel and I'll be right back.
No, can't do that. You're gonna have to do this with a headache. Here you go. back in open court at 11:52. Executive session is over, open court is resumed. Gonna deliberate and consider possible action regarding consultation. And does anybody have anything on item 22?
No action.
No action. Item number 23.
Motion.
Motion Commissioner Snuggs, second Commissioner Arndt. All in favor? Aye. And once again, I'm the bad guy. I'm the one. Tom's gonna shoot me.